Next bill on the agenda is House File 2253 from Representative Sundin. Representative Sundin, would you like to move your bill?
Thank you, Mr. Chair. I'd like to move House File 2253. It's a Workman's Comp Advisory Council bill. With me today, I have Commissioner Roberts from the Department of Labor and Industry to testify on the bill. This is the product of cooperation between parties, and the parties would be labor, insurance interests, and Chamber of Commerce, and the Department of Labor as well. So this is a culmination of some of the technical fixes and the one extension of the presumptive language that we heard from Representative Wogelmond. So with that, I'll leave it to the Commissioner to testify and explain the bill in detail.
Representative Sundin moves that House File 2253 be re-referred to Ways and Means. Representative Sundin, we do have an author's amendment, the A21 amendment. Would you like to move the amendment and explain it?
Just include the amendment, and the Commissioner will explain. So I'd move the amendment.
All right, Representative Sundin moves the A21 amendment. All those in favor of adopting the A21, please say aye.
Aye.
Opposed, say nay. Motion passes. The amendment is adopted. Commissioner Robertson, please identify yourself for the record and proceed.
Good afternoon. For the record, my name is Rosalind Robertson. I am the Commissioner of the Minnesota Department of Labor and Industry. To begin, I'd like to thank Chairman Eklund and the members of the committee. I am pleased to be here today to speak in support of House File 2253. I want to thank Representative Sundin for carrying the bill and for his support and participation on the Workers' Compensation Advisory Council. As Representative Sundin mentioned, the bill before you today represents the work undertaken by the Workers' Compensation Advisory Council over the last several months. The Advisory Council held 5 public meetings in December, January, February, and March, during which it received written and public comments on the proposals included in this bill. The department revised the proposals based on public comment and recommendations made by the council. The council passed these recommendations with unanimous support at its March 10th meeting, and therefore the bill has the full agreement of both business and labor. As committee members may know, the Workers' Compensation Advisory Council has a statutory charge to review and submit its recommendations to the legislature each year on proposed amendments to Chapter 176, the Workers' Compensation Statute. The workers' compensation system supports employers, insurers, medical and rehab providers, and most importantly, injured workers, to ensure employees injured on the job receive the benefits and services they need to recover from an injury and return to employment. The Advisory Council includes the presidents of the largest statewide Minnesota business and labor organizations, as well as 5 members representing business and 5 additional members representing organized labor, as appointed by the governor, the majority leader of the Senate, the Speaker of the House, the minority leader of the Senate, and the minority leader of the House. The Advisory Council may not recommend proposed legislation unless it is supported by the majority of the employer members and a majority of the labor members. Because of this process, the Advisory Council bill is generally respected by the legislature and proceeds without amendment. However, the amendment that was adopted today was a grammatical clarification that was brought to our attention by the Minnesota Chamber of Commerce, and after the Advisory Council had agreed to the recommended overall language. The amendment was discussed with and agreed to by the Minnesota AFL-CIO. Members should have a copy or a summary of House File 2253, but I would like to briefly describe the provisions. Section 1 of the bill updates the minimum weekly compensation rate for temporary total disability. The current minimum benefit level, which was last updated in the year 2000, is the lesser of the employee's actual weekly wage, or $130. This language sets the benefit level at the lesser of 20% of the maximum compensation rate, or the employee's actual weekly wage. The annual change for the minimum compensation rate will then be determined by the statewide average weekly wage, the same as the change used for maximum temporary total disability benefits. Section 2 of the bill, starting on line 4.7, adds a new subdivision to section 176.136 that allows the department to assess a penalty against a healthcare provider who bills an injured worker for treatment, which is prohibited by the workers' compensation law. This language also authorizes the commissioner to order the provider to reimburse employee costs and expenses incurred because of the violation. The department receives these complaints after workers' compensation insurers or employees have told the provider that the bill should be sent to the insurer, and the provider has continued to try to collect from the employee. Providers have sent employees to collections, have filed claims in conciliation court, and have even attached employees' tax refunds. Sometimes employees pay the bill. The language requires prior notice to the provider of the law and who the insurer is before Labor and Industry can assess a penalty, and any associated costs or expenses can be assessed. Sections 3 and 4, starting on line 6.4, update the workers' compensation fee schedule statute for payment of inpatient hospital fees in Minnesota statute, section 176.1362, to require use of a new Medicare web-based calculator to calculate the maximum fee inpatient hospital treatment for discharges on or after October 1st, 2021. Medicare is currently phasing out the existing downloadable pricing tools, which is currently used to calculate inpatient hospital payments under the statute, in favor of a web-based calculator. Therefore, the statute needs to be updated to reflect this change made by Medicare. Section 5 through 7, starting on line 7.29, update the Ambulatory Surgical Center, or ASC, payment statute in section 176.1363 to provide technical changes. DLI published a study in January on the impact of the ASC statute, including the timeliness and accuracy of ASC payments. The changes in these sections were recommended to improve payment accuracy based on the results of that study. Specifically, the language describes the multiple surgical procedure billing requirements as opposed to referencing Medicare regulations. It clarifies when payment to the ASC is based on actual charges instead of fee schedule amounts, and it deletes inapplicable cross-references and phrases. Section 8 and 9 revises Section 176.194, which sets out prohibited conduct by workers' compensation insurers and other payers, and their adjusters and third-party administrators who act on the payer's behalf. The statute provides for warnings and penalties for payers who engage in prohibited conduct. The changes clarify that it is a prohibited practice for a payer to fail to pay or deny medical bills within 45 days after the receipt of all information requested from medical providers if the requested information is necessary to make a payment determination. This is added because sometimes the information requested is not required to be provided under the workers' compensation law, and therefore the lack of information is not a valid reason to deny payment. Section 10, starting on line 12.16, revises Minnesota Statute 176.223, which required the department to issue an annual report on how often payers pay or deny benefits within the statutory deadlines. This report will now be based on data for each claim that the payers file in Workers' Compensation Campus, the department new technology system. Because Campus just went live on November 2nd, the language delays the first annual report until March of 2022. The language also allowed the commissioner to exclude incomplete or unreliable data and require workers' compensation payers to electronically file corrected data in Campus by February 15th for the data to be reflected in the annual report. Finally, the language provides that the reports do not need to be sent individually to payers because they can now see their information in Campus. Section 13, starting on line 13.13, updates Minnesota Statute 176.351 to prohibit subpoenas of the Department of Labor and Industry employees unless the department is a party to the claim or enforcement actions or provide vocational rehabilitation services to an injured worker. This section is needed because labor and industry employees from all of the workers' compensation units, including the workers' compensation ombudsman, the help desk staff, the compliance and the alternative dispute resolution staff, receive calls from employees, employers, insurers, healthcare providers, rehabilitation providers, interveners, and attorneys who have questions about the workers' compensation law and its procedures. Under Minnesota Statute 176.261, the department is required to try to settle problems of employees and employers who contact labor and industry for help. The new language in this section is in response to a subpoena received by a department employee from an attorney. The attorney wanted the employee to testify in a deposition about a question the attorney had asked the department employee related to the workers' compensation law and rules. The department was successful in objecting to the subpoena, but only after litigating it at the Office of Administrative Hearing. Allowing department employees to be subpoenaed will limit our ability to provide information and assistance to callers and users of the workers' compensation system. Finally, Section 12 of the bill, starting on line 13.227, extends the sunset date of the current workers' compensation COVID presumption statute, Minnesota Statute 176.011, Subdivision 15, from May 1st, 2021 to 11/59 on December 31st, 2021. It provides, as does the current presumption statute, that once sunset, the employee is still entitled to claim workers' compensation for contracting work-related COVID-19, but as with other injuries and illnesses, the employee is no longer entitled to the presumption that the disease was work-related. That concludes my prepared comments relating to House File 2253, and I'd be happy to address any questions that the committee have.
Thank you, Commissioner Robertson. Any member questions on House File 2253? Seeing none, Chair Sundin, thank you for bringing this bill forward. It's a good bill to take care of our workman's comp issues. I appreciate the hard work that you and your committee have put in on this. And any closing comments? Chair Sundin, you might be muted again.
Thank you, Mr. Chair. I thank the committee for hearing the bill, and I'd just like to renew my motion and ask for support from the committee to move this to.
Representative Sundin renews his motion that House File 2253 as amended be re-referred to Ways and Means. Ms. Doyle, please take the roll.
Chair Eklund.
Yes.
Eklund, aye. Vice Chair Zhang.
Aye.
Zhang, aye. Representative Detmer.
Detmer votes aye.
Detmer, aye. Representative McDonald.
All right, McDonald, aye.
McDonald, aye. Representative Berg.
Aye.
Berg, aye. Representative Bliss. Representative Bliss.
Aye.
Bliss, aye. Representative Edelson.
Aye.
Edelson, aye. Representative Frederick.
Aye.
Frederick, aye. Representative Greenman.
Aye.
Greenman, aye. Representative Nelson.
Nelson, aye.
Nelson, aye. Representative Poston.
Aye.
Poston, aye. Representative Raleigh.
Raleigh, aye.
Raleigh, aye. Representative Sundin.
Aye.
Sundin, aye. There are 13 ayes, 0 nays.
13 ayes and 0 nays. Your bill's on its way to Ways and Means, Chair Sundin.